We will go on the record in the matter 24 CF 69, State of Wisconsin versus Joshua Staples. The state appears in person by District Attorney Kevin Schmidt. We have Mr. Staples appearing in person in custody with his counsel, Stephen Ripple. We're set here today in this matter for, I believe, the sentencing portion of this case. Mr. Staples pled guilty to count 1, burglary of a building or a dwelling, a class F felony. Ms. Bauer, are we in victims' rights compliance?
Yes, Your Honor.
The court did order a pre-sentence investigation report. The court has reviewed the report, and I don't recall anything jumping out to the court as being any mistakes that I would notice, which would be material. Mr. Schmidt, did you receive a copy of the pre-sentence investigation report?
I received it. I reviewed it. I have no corrections.
Mr. Ripple, did you receive a copy of the report?
I did, and I reviewed it with Mr. Staples, and we do not have any corrections.
All right, and that's accurate, Mr. Staples. He did review it with you,
Yes.
and you
Ms.
did not
Shawna?
notice anything that would need to be corrected or stated on the record?
No.
All right, thank you. Mr. Schmidt, we will turn, well, first, I'm going to guess no victims are making any statement here today.
That is correct, Your Honor.
And is there restitution requested?
It's been paid.
Everything's been paid. All right, we're good to go. Argument and sentencing recommendation, Mr. Schmidt.
Just for clarity for that, I believe it's been paid to the clerk of courts, so we'd still need to order it. It's the $1,000 deductible. Am I recalling correctly, Olivia? I don't believe it was paid to our office.
That's my understanding as well.
Yes, I can see 700 paid on April 10th, 2026, and 300 paid on May 11th, 2026.
Okay. With that, for my argument, the state's going to be recommending some,
1 second,
Oh.
can you confirm the total amount of?
Restitution.
All right, thank you so much. Sorry, Mr. Schmidt.
sure. The state's going to be recommending something of a 2/3 sentence, which is the high end of the Department of Corrections recommendation, which is 4 in, 4 out. I start first with describing why the Department of Corrections concluded that a prison sentence is appropriate here and that probation would not be. That is, the seriousness of the offense is the most obvious reason why. This was a planned burglary where several $1,000s were stolen. It is a serious offense. Businesses might go under if they are burglarized, and then the community as a whole is at a loss for that lack of a business. Furthermore, the offense of burglary is classified as a crime of violence for a reason. It is an offense where, even though it lacks the element of violence in its description, in its definition, by its very nature, entering into someone's structure for the purpose to steal or commit a different felony, it carries with it a high risk of confrontation, and confrontations in the home with nowhere else to retreat to are highly likely to be very dangerous, especially when you're talking about an offender whose criminal history itself includes possessing firearms and battery and assault. Furthermore, when you look at this offender's adjustment and supervision, it has not been good. He simply does not adjust well on probation. He hasn't for decades. Not only that, but many of his convictions are directly related to not following court orders already. 2021 conviction for not fulfilling registration requirement, 2016 conviction for possessing firearm despite a prohibition, 4 separate convictions for violating no contact orders, 3 of which is repeater. One of them had an additional account of domestic assault within the same case. He's also lied to police about his name or fled police to escape capture, as indicated by DOC's criminal history. In fact, during the duration of this case, he had multiple missed court appearances as well. Thus, probation is inappropriate threefold. It would unduly depreciate the seriousness of the offense, as I've outlined first. This offender needs correctional treatment only available in confinement. That is, if he's not adjusting in supervision well over a long period of time, then we look at confined setting treatments. And confinement is necessary to protect the public. It would do nobody any good to release an offender on probation when he does poorly on probation to begin with, and he doesn't follow court orders generally. We shouldn't set him up for that failure, nor risk our community by doing so. So next, what the court should consider is what is the minimum amount of confinement consistent with protection of the public, gravity of the offense, and rehabilitative needs of the offender. I think this is a case where there's a real need for both types of deterrence, specific and general. As to general deterrence, our county historically has struggled with burglary because of the rural makeup of our community. It's simply easier to do burglaries here versus a large city where there are many neighbors, they're close together, there's much more lighted ways. Neighborhood watch type things happen versus a rural community where there's just a lot less people about, structures are further apart. And as a result, it's an explicit problem in our community, and we have a great interest in deterring other people from doing it. That is, these sentences are a real opportunity to send a message to those people, to the other people who might consider doing burglaries in our community, no. As to specific deterrence, I'm concerned this is an offender who historically has been given numerous probation, jail, and even prison sentences in his life. And ours is a criminal justice system that's really designed to ratchet up sentences over time in order to deter offenders. That is, if a sentence of probation doesn't work, we look at jail. If jail doesn't work, we look at prison. If prison hasn't been working, we ratchet up the amount of prison. We begin to think about incapacitation as a goal for truly persistent recidivists. This individual has had multiple short-term prison sentences that don't appear to have caused correction in his criminal thinking or other underlying criminogenic needs. Furthermore, while I do appreciate he has paid back the insurance deductible for the victim of this case of the burglary is going to be made whole. That indicates remorse. It indicates a desire to make the victim whole. It is something the court should absolutely consider as a mitigating factor. There is also an element, however, that Staples is coming out ahead of this financially. He paid back the insurance deductible, what the victim is out of pocket for, but not the whole amount stolen. And the reason I bring that up is for purposes of specific deterrence. When you have an offender who steals a large amount of money and they only have to pay back part of it, then they've still come out ahead, at least financially. And I believe that for specific deterrence principles, incarceration can fill that gap to make sure we don't have people who say don't care about short-term sentences or probation sentences if they'll come out ahead in the long term financially. In that case, incarceration can and should balance out the rest of that punishment equation. Finally, on that topic, this case does merit considerations of punishment and incapacitation. Aside from this conviction, this offender has 16 other criminal convictions. Those convictions include felonies, another theft, violence, stalking. I already described the ones that are just kind of general disobedience of consequences of his actions. The history reaches back to 2004, making it a 22-year criminal history, age 22 to 44 for this offender. You don't need the compass instrument to look at the history and the age of the offender to extrapolate into the future of this one. This is a person who is of great risk of reoffending in the future. To that end, incapacitation should be something looked at and considered in this sentence, especially when you consider that 9 of the 16 convictions are victim-related crimes, as opposed to, say, when we have people with simple possessions where, there's not a victim, or if there is a victim, it's either society or themselves. 10, if you include the burglary today, actually. For those reasons, the state believes that 4 in, 4 out is consistent with the McCleary-Gallion factors. Maximum penalty on this offense is 7.5 in, 5 out, meaning that we're a little bit under the 2/3 mark with this recommendation. We're using a little above half of the initial confinement time allowable and 80% of the allowable extended supervision. I believe this is the minimum amount of confinement based upon those factors for this offender in particular, looking at his personal characteristics and looking at the facts of the case. Thank you.
Questions first before I move on to defendants and defense arguments. I see that there was a co-defendant, the cleaning lady of this restaurant, but it's my understanding she was not charged in this. Jean Bradshaw is what comes up in the PSI.
Hang on, let me read the charging notes because I assume you're asking why wasn't she charged?
Correct. If she's a co-defendant or a co-conspirator, why wasn't she charged? Why does it all fall on his shoulders?
Because she was going to be an essential witness and she helped give a bunch of information on it.
So then this, I believe this was before your time perhaps, but then she was given the deal to be the witness and then she wouldn't be charged.
Wasn't a deal, it was more. There are elements of the evidence that would have made it harder to charge her than him. That is, what she would have said is the way he got the information is that I mentioned it to him and he must have done this on his own.
I read in the notes of what occurred that night. They were both present. They were both viewed on the camera.
There was a woman there, you could not see her face.
All right, so that's why. Just couldn't make her out. I thought it said that they were both identified.
I can
thought-
clarify, I can clarify. this.
Yes,
A month before the burglary, Jeannie Bradshaw showed up to work cleaning with an unknown male. And so after the burglary happened, they went back and looked through the video and found this. Their cleaning lady with another man there that had no business being there. So immediately, these were their two suspects. But they just couldn't identify Joshua Staples.
all right. And so she coughed up the information, gave the information and, okay. All right,
Our
Okay.
office never received a referral for her because of just simply what the evidence was.
okay. I thought I had read in the video that the law enforcement identified both. One is Jean Bradshaw and one is Joshua Staples. I just want to make sure that I'm reading what was accurate. And that I sentence on what is accurate.
As in the footage where she was identified was 2 days prior. She was in there cleaning with an unidentified male. She is the one herself who called the sheriff afterwards.
She was
Alright.
identified a month prior. It was a month prior that the two of them were cleaning together.
Okay, I understand now. I got it. All right, and question for defense prior to, Mr. Staples, he's serving time in Minnesota, is that correct?
Yes,
Yes, Your Honor.
And on what charges?
Failure to register for a predatory offender,
And how long is your sentence over in Minnesota?
39 months.
And are you engaged in, or would you get any time off for that 39 months if you do programming or
Well,
anything?
in Minnesota, you do 2/3 of your time, but when I went through St. Cloud E-House, I took it upon myself to enroll in a 3.5 high intensity treatment center, and that's in Lino. It's the highest treatment program they got in that state. I've also enrolled in college courses in the same facility for Native American arts.
Okay. And Mr. Schmidt, I think I missed it. Are you asking consecutive or concurrent?
I'd ask for consecutive.
Consecutive to his Minnesota.
And the basis would be it's a different type of crime, different location, and that is the reason why.
All right, okay.
to finish up on that point, it would appear, he told me that his release date is July 12th of 27.
July 12th of 27. All right, thank you. Okay. Argument and sentencing recommendation, Mr. Ripple.
My sentencing recommendation is for 3 years of prison, 1 initial confinement, 4 years total, 1 initial confinement followed by 3 extended supervision to run that concurrent to his Minnesota case and to make him eligible for the substance abuse program. I agree with the state that probation is not appropriate here. And when he indicated that confined setting treatments are key, I completely agree with him. Much of his argument was about the nature of burglary cases, but really this case is about drugs. As to the facts, it is all about drugs, specifically methamphetamine. Mr. Staples was in a relationship with this person, Jeannie Bradshaw. She was a cleaner and she was employed by the victim's bar. Their relationship was based simply on using drugs together. She had the code to shut down the alarm. My client says it was her idea. Bradshaw says she was threatened into her role. As I was saying, about a month before this burglary, Bradshaw and Staples appeared on the security camera to be cleaning the victim's bar together. Mr. Staples really had no business being there, and when the investigation began, it amounted to them casing the bar, researching for the burglary. A month later, this burglary occurs, and Bradshaw's codes were used to shut off the alarm. It didn't take the investigators a long time to determine that Bradshaw and this unknown male were the likely suspects, and what they really needed was just to ID the male. And then about 6 days after the burglary, Bradshaw makes an appointment to talk with the Burnett County Sheriff, and she identifies that suspect as Joshua Staples. She was already on the radar. She had not gone to work since the burglary. She had not even gone there to pick up her last check. She said he threatened to kill her. I didn't find the statement particularly credible. The details were vague. She was clearly trying to exonerate herself. She's a drug user herself. She has a criminal record. She had open cases at the time. When she came in to make her statement to police, she actually stopped by the public defender's office to pay her public defender fee for her open cases. Looks like she had recently a possession of drug paraphernalia, also a battery or threat to law enforcement officer. The police admitted that she was on their radar. They said, "We knew you knew something." She repeatedly used it as a time to detail her alibi, which wasn't much of an alibi. It was, I was alone. I wasn't there. I was alone. I was at the hotel. They clearly knew her from past contacts with the police. The state did not issue charges for Bradshaw in relation to this. That's their decision. The state also did not issue charges against Mr. Staples for threatening to kill her. The whole thing seemed, again, to be not credible, it seemed like she was involved and she was trying to keep herself on the right side of this. I'm not here to argue that Bradshaw should have been charged. My point is twofold. One, Josh did not act alone. There was social pressure from this person he was in a relationship with to get this done. And she assisted. She took him there. She gave him the codes. This burglary would not have been done without those security codes. Defense maintains that these codes were given to Joshua by Jeannie Bradshaw freely and voluntarily, and there's no credible evidence of these threats. My second point here, besides that he did not act alone, is that the pre-sentence investigation at some point indicates that he is minimizing his involvement in this and not taking responsibility. I have not seen that he has done that at all. He has been very accepting of responsibility with the plea. He's been forthright with information, ready to resolve. My only indication that he's been not willing to take responsibility is that he said, "I did not act alone." And I think that is true. The victim of this filed a victim impact statement and said that Mr. Staples is a professional thief. That is not true. His record is tied to drug use. Once Josh was ID'd, there was overwhelming evidence of his guilt. The police would have eventually identified him. It was a matter of time. Once they got warrants to get into Facebook and Facebook Messenger, there were conversations he was having about the burglary. He sent a couple different people messages saying, I'm working on a job, and sent pictures of the victim's bar. A professional would not have done that. His DNA was left on a hatchet that was thrown through the window. Not only did he leave the DNA there, but he left the hatchet there. Again, not a professional. And with everything that's found in the Facebook Messenger, all the conversations I read and really pretty stupid things he said, never once did I see him threaten Jeannie Bradshaw or play a power and control dynamic with her to force her to follow this stuff along. Also, they're not very professional. Mr. Staples showed his face to the security camera a month before this happened. Once they saw that, they knew who to look for. His current incarceration is for failure to register as a predatory offender. It's a violation of probation. In the fall of 2025, so after this had happened, and right around the time he warranted here, he left sober living to establish housing for at that point, a 12-month-old child who had a pending CHIPS case. He couldn't establish residency. He was homeless and relapsed. He warranted here. He absconded on probation. He was arrested on January 5th of 2026 for sleeping in his car. So there were no new charges that came along with that. Again, his release is in July of 2027. He's at Lino Lakes. It has 1,300 beds. It has substance abuse program unit with 305 beds. He was placed in this facility because of his needs. And so this is confined setting treatments that he is involved in. And he's in the 3.5 high intensity treatment. Minnesota knows his needs. He's mainly based out of Minnesota. He's scheduled to earn college credits starting this August. He was moved to Burnett County to resolve this case, and he's done so. I also filed 3 documents under document 51 showing that he's completed programming here. Great Expectations, Parenting as Children Grow, and Restorative Justice. He worked on an apology letter. He paid his fees. And I think this is a proof that he's making an effort to make things right. He has paid the restitution. I hear and understand the state's argument that he came out ahead on this, but that's not what he's trying to do. There's really no avenue for him to break this even. If I assume the second victim would be an insurance company, they haven't come forward and identified that they're seeking any restitution. So I don't know what Mr. Staples can do to not come out ahead on this, but I believe he'd be willing to pay this restitution. As far as a personal background of Mr. Staples, he was raised by his mother. He barely had a relationship with his father. He spent the 1980s in St. Louis, Missouri. His mother worked for the St. Louis Cardinals. He became a baseball fan. He had family in the area. He had stable housing. One of his family members drove a city bus, and he spent his time getting bus rides to either Busch Stadium to see the Cardinals play or going to the Boys and Girls Club. He said it was stable childhood. He was happy. In the early 90s, he moved to Hinckley, which brought a big adjustment negatively. He was living with his brother's biological father, who abused drugs, abused alcohol. He witnessed abuse. He was the victim of abuse. He witnessed drug abuse. He witnessed alcoholism. And it's very predictable that he started using alcohol and drugs at an early age. He was a single father by the time he was 17. He has 11 children. There are 5 that are under 18. The youngest is 18 months old, and there is a CHIPS action in Minnesota regarding that. Mr. Staples is motivated to become the parent who can have placement because the mother used drugs while she was pregnant. He had court on this CHIPS matter this week, and it appears that the court is pushing the matter back until Mr. Staples is possibly released to see if he could become the parent. That is his plan. His criminal record shows that he commits crimes when he's not clean. I reviewed it with him. In 2021 to 2012, there was a run of domestic cases. This was another relationship based on drugs. It sounds familiar. They have no children in common, but it was the drug use that got him into this. There are periods of sobriety. You know, the argument that he simply does not adjust well on probation isn't 100% correct. He adjusts well for periods. He has made progress on sobriety and staying clean, but he has emotional triggers that compromise it. For example, right before this case happened in 2024, he was in sober living in Chaska, Minnesota, and then he was told his mother has cancer and 30 days to live.
2021.
I'm sorry, what?
2021.
This was 2021. I'm sorry. It was 2021, and his mother, he's informed that his mother has 30 days to live. He left treatment to see his mother. She died, and eventually he relapsed. And then within the same year, his father mysteriously and suddenly dies, and he doesn't even know how that happened. The assumption is that there's some sort of family fight over the money. In 2025, when I was appointed to this case, Mr. Staples was living in transitional living called Transitions in St. Paul. He was clean. He sent me copies of drug tests showing he's testing negative. It was the CHIPS case that caused an emotional breakdown. When he left sober living, he absconded from probation. He warranted here, which caused his incarceration in Minnesota. I think the summary is that treatment is key. Minnesota seems to have a plan in place and the resources available for Mr. Staples. Mr. Staples' life is there. That's really where he's from. He does not have any connections to Jeannie Bradshaw. They are not dating. They have not spoken. They have no children in common. He was at this high intensity treatment center in Minnesota. This is all about the AODA needs, and Minnesota knows what this is about. He has no connection to Wisconsin. He was just here because of Jeannie Bradshaw, and that relationship is done. His plan is to hopefully continue treatment in Lindo Lakes, reside in St. Paul, at Transitions for sober living, seek employment with his tribe because his criminal record is causing problems with maintaining or obtaining employment. He needs to work on his emotional triggers. As for showing of good character, there is the treatment that he has done in Minnesota. There's the treatment and programming that he has done here in Burnett County. He has paid all the restitution that has been there for him to pay. He had $1,000 bail forfeited. It looks like there were 2 periods of incarceration here, from April 10th, 2025 to April 21st, 2025 for 11 days. And then February 5th, 2026 to today, which is 132, totaling 143 days. Again, my recommendation is for 1 year initial confinement, followed by extended supervision, to run a concurrent to Minnesota and make him eligible for the substance abuse program. And the basis of that request is the need for AODA treatment. And I think the community has a great need for him to obtain that treatment as well.
So you said 1 year confinement and 2 years of extended supervision, or what did you say? I thought in the beginning your recommendation was 3 years.
It was 3 years.
So you've changed it now that you've argued?
Nope, I misspoke.
Okay.
3 years.
So you're asking for 3 years of confinement? What are you asking for?
I'm asking for 1 year initial confinement followed by 3 years extended supervision to run a concurrent to Minnesota and make him eligible for substance abuse program.
All right. A couple things I do need to clarify or state. You had stated in your argument that Jean Bradshaw came to the government center at some time to pay her public defender fees. You can't do that here. So she would have had to go to Spooner. She would have probably paid court fines and fees here.
Then that must be what she paid.
And that's probably it. That's not a material fact. I just wanted clarification. And I just need to make sure and clarify that that the state is in the confines of the agreement that the parties have reached. It was my understanding that the state is free to argue, but capped at the pre-sentence investigation, the DOC recommendation. They did cap it at the DOC recommendation, but then the state asked for consecutive, and I just want to make sure that that wasn't part of any deal. Because the pre-sentence investigation, the DOC recommendation doesn't state consecutive or concurrent. So are they in the confines of their agreement that they've reached with you with free to argue capped at recommendation?
I would argue no, but that's your decision.
I would argue yes, because our agreement didn't say one way or another.
And that's why I would argue yes too. And simply because the DOC did not, and usually does not state consecutive to any other state's sentences. They would if it was a Wisconsin sentence. But yet they are silent in this. And so I just wanted to make sure that everything was stated on the record and that everybody had a chance to make any statements on the record that they feel necessary. Anything you want to add, Mr. Schmidt,
No,
Mr. Ripple?
Well, I want to add a brief argument for concurrent time, and it is that this is part of the same relapse and the same general bulk of criminal behavior that Mr. Staples was involved in at this time.
Thank you. Mr. Staples, I am now going to turn to you and have you provide any statement, any information that you want me to know before I decide what to do here today. If you've heard anything that you think needs to be expanded on, or if you've heard anything that you need to let me know, any differences of opinion or thoughts, etc., to correct any mistakes.
Okay. My name is Joshua E. Staples. My Ojibwe name is Monituk Gwiwizen. That's my real name. It means spirit boy.
May you please spell it for the record?
MANI''TOUQ GWIIWIIZEN. Monituk Gwiwizen. It means spirit boy in my language. Can I speak in another language?
No, I will not understand it, nor will the court reporter be able to take it down. I
Okay.
will allow you to do that. However, I am going to state then the court reporter is not mandated to take it down since we will not know your Ojibwe language. But if you want to do it, I will give you that opportunity and then you can speak it in English.
Yes.
Okay, so you're going to speak in Ojibwe?
Yeah.
All right, so we're off the record.
All right. Bonjour, Melissia Mogen. Dapana Anishinaabe Asema. Monituk Gwiwizen at this near cars, Magazi Indodum, Ajmogan Jit to the Bayan. Wabanang, Jawanang, Nagabinang, Gewedinang, Mama Ki, Ispiming, Bimara Diziwin. Ambe Ocho Shante Ambe no Kewe, Ambe no Kewe, We Katako, Katako Ayueo. Miigwech. I just said,
And then now we're back on the record.
hello, Melissia Mogen. My name is Spirit Boy. I'm from Lake Lena, Minnesota. I'm Eagle Clan. As I said before, 7 directions. We have 7 directions: northeast, southwest, Mother Earth, and up above. And Bimara Diziwin means the good life inside yourself. And Ambe Ocho Shante Ambe no Kewe, Ambe no Kewe, We Katako, Katako
If you're going to
Ayueo.
say those things, I'm going to need you to spell them because my court reporter needs to take them down or.
I'll just say it in English.
Okay,
It just says I'm here today with my attorney. After this that is behind me, I'm ready to move on, get on my life with my children together forever. There's not a day that goes by that I don't think about why I got mixed up with that person. I became a single father at a young age, 17. I dropped out of high school. I went back when I was 19. I got my GED, and I was raising 3 kids by myself at that time. So I became an instant family, single father. I got into firefighting in 2001 with my uncle and my brothers through the Mille Lacs Band. Traveled around state to state, fought fires. Met a girl up there, and, everything was going good, and just said that was the time I got involved in the drugs, was around when all that domestic started happening in 2008, 2009, 10 with that other girl. I was never in trouble. I never had a legal, adult legal record till I met that lady where drugs was involved in my life. I was working man, a single father at that time. Didn't really know much about drugs until I came up here from St. Louis. Then from living from a city with millions, and I come up to here to Hinckley with about 900 people. I just kind of messed with me. Like, where did everybody go? And it kind of messed with my head moving out to the country rather than living on the street, jumping on the buses and just go hang out, at the Boys and Girls Club. They didn't have that up here. So I had to find ways to introduce myself, and then to please or whatever. And then kids in school. I know I had a big family up here on the Minnesota side, and they were all smoking weed. And you just at that age, you don't want to be left out. So you join the crowd and you do what they do. But that's neither here nor there anymore. I just got hooked up with some bad women, and they all do drugs, and it's crazy, man. Like, every girl I've been with always had drugs. But like I said, there's not a day that doesn't go by. Why'd I do this? And I should have stood up and said, man, this is a bad idea. Because not only did it broke the law, but it took me out of the game with my children. I raised all my kids. And I'm not with them right now because I'm hearing some bad decisions. And when you're addicted to drugs, especially methamphetamine, man, that takes over your thinking. And me and my children are paying the ultimate price of being away from each other. Now they're living with family and friends and my old coach. One of my baby moms, I lost her like 3 months ago being here. She passed away from a heart attack. Now my youngest daughter is with her sister, my baby mom's sister, and she's confused. She don't know what's going on right now. As far as going by every day, I try to ask for forgiveness, but I do it within myself because, like, man, I wouldn't be in this mess if I would have never hooked up with Jeannie Bradshaw. I'm real sorry to Yellow Lake Lodge because it was stupid on my part. I know I lost trust with them, the community, and amongst other things. As far as when I was in St. Paul working and I couldn't find a job, I got to register as a predatory offender for something I was never charged with. And it's every time I go into a job interview to explain that, and I ask people, I said, man, there's nothing on my record that would make me have to register for a predatory offender. And they said, what do you got to register for? I said, for false imprisonment. It was a first-degree assault with false imprisonment. I let a female go. She's the one that gave the statement, and I got into a fight with the guy. That was thrown out of court. They're making me register for that. And every time I go try to a job interview, and I ask them, why I didn't get a job, and they said, well, because you got to register as a predator. And I ask people, well, what do you think of when somebody says they have to register as a predatory offender, and they say a sex crime? I'm not a sexual offender, but that's what the majority of the people out there nowadays, they say when you ask them, what do you think he's got to register for? They're going to say a sex crime. I'm not a sex offender. Nor does it say anything on my record that I have to register for. I got screwed out of a deal over there, but it is what it is. I started coming to terms with that every year. I got to do it now. So yeah, and as far as probation, I was on probation for, I think that was in 2021 for that I was 5 months, when I was in treatment in St. Paul. I was 5 months getting off probation over there for that predatory offense, or registering for predator, whatever. As well as going to court for the CHIPS cases to get my son back. There's no programs over there for fathers and sons in halfway houses. So when all the programs started getting shut down over there for fraud, I was the unfortunate one where I had to move around and trying to find housing on my own without no help or anything. It was, it was hard. I never gave no bad UA. I was on probation for almost 5 years. 5 months of almost getting off, my parole officer executes me, gives me 39 months. That was a hard pill to swallow. I had to give up going to court for my kids. I was so close to getting my kids back. And all I had to do was find housing. And I couldn't find housing within the time. And then for some reason, my parole officer wanted to execute me for failing out of programming. But up until that point, I completed 3 programs: North Star, Transitions, and Create. Create's one I believe that got shut down because it was part of New Way. And I had to move around. She violated me for that. When in fact I told her that it's hard for me to get a job with that predatory thing on my record, and I don't know what I have to register for. She knew that, and she just kept pushing it, getting a job. I collect travel payments every month. I mean, I told her I'm well financially well balanced. If when I'm not on drugs, I can take care of myself and my kids. I got 11 of them. The 2 that are in CHIPS right now is through my baby mom, and she's got a drug problem. She's working her program. I went to court yesterday, and I told the courts what was going on, and they're willing to push this out. So they got my plan. They know I'm getting out January 12th. They got my treatment stuff. They know I'm in a 3.5 high intensity and my college class, and they're all for the wait for me to get out on January 12th, because they know I was so close to getting these kids back. I've raised all my kids on my own. I don't keep any of my children from their mother. But yeah, that was a hard pill I had to swallow when she violated me for 39 months when I was 5 months getting off probation. I did 5 years on probation with that lady, and 5 months, almost 5 years of probation with her. And 5 months to the day I was gonna get off, I mean, she violated me, man. That was the hardest pill I had to swallow, because I didn't have to turn over my kids, and it hurt. Now with my baby, her mother passed away from a heart attack, and then it's just, I was looking forward to getting out next year and just taking my kids and trying to pick up the pieces and move on. I mean, they have nobody else to care for them. I mean, everybody that spread my kids out, and everybody's asking, man, Josh, we need you out here, man. And that's what they're planning on for next year. And I said, I'm hoping I'm doing what I gotta do to get to them closer, because I mean, it's not only that's me that's hurting, it's them and my family and friends who are helping me out during this. I'm starting out with some college classes in Lino Lakes, because my tribe says no matter what, I mean, they're gonna hire me. They got offices in Southside Minneapolis, right too far from where I live. That's why I'm trying to get some degrees under my belt. I mean, I speak the language fluently. My family's very traditional. And it's good to get some education under my belt so I could take out with me, so I can have some kind of a plan set up for me not to break any more laws. I mean, and I do well with my children. It's just I don't know, it's just drugs are a bad thing out there, and they do take you and take over your life, and it has mine took the most important things away from me, is my children. And, you know, I lost a lot of trust in this county with people, and I mean, that's not my thing because I get along with everybody. I just made a few bad decisions that I'm ultimately paying the price now. I would like to thank my attorney, Stephen Ripple. He's been great. I mean, I appreciate everything he's done for me. I apologize to the court for wasting your time for this, you know, bad decision on my part. I can't speak for nobody else. I can just only own up to what I've done, and I'm trying to make right so I can get out to my children. Thank you, Your Honor.
Thank you, Mr. Staples. I definitely understand what you're stating and why you're stating that. 11 kids is a lot of kids. That's a lot of children. But it sounds like other than being in custody and when you are not under the influence, that you strive for and you are a good dad. It sounds like you're the one who has been taking care of them, again, when not in custody or under the influence. And so I'm sure you have your family that help as well. Because again, raising one child is difficult. Raising 11 has to be very
It's tough.
consuming. Yes. When I look at this case and in sentencing, I have to look at the seriousness of the matter. I have to look at you, Mr. Staples, your criminal history, I have to look at your needs for rehabilitation, whether or not there's any remorse, or if you have any ideas on changing your life. I have to look at protecting the public. Mr. Schmidt is correct when he states that I also have to look at deterrence, not only specific deterrence to deter you from committing additional crimes or crimes like this, but general deterrence, deterring others from committing crimes like this and other crimes. Before I get into the sentence, though, I want to make sure that I have an address, because we only have the address right now with the Burnett County Jail, and then you'll probably be shipped back to Lino Lakes or wherever you're going to go. Do you have an address where your mail can be sent to?
1830,
Is it 1830?
yes,
1830.
Forest Court, CT, Cloquet, Minnesota, 55720.
And is that whose house is that?
That's my uncle's on my dad's side.
All right, uncle's house. And would you have a telephone number that we would be able to reach you at?
With that address,
Yes. Or
Um,
any number where we know that we could get a hold of you if we need to.
218-608-2527.
And whose number is that?
That's my uncle Kevin Defoe, the owner of that house.
Oh, great. So, so it's Uncle Kevin, and what's Kevin's last name?
Defoe,
Defoe.
Defoe.
Exactly how I thought. Okay, thank you.
You're welcome.
So knowing those things, then I have to look at the seriousness, and I have to look at you, and I have to look at the public. Mr. Schmidt is very correct in the fact that with regards to burglaries of a building or a dwelling, they are by the very nature serious. They're defined as being serious for many reasons. One, because you may not know who is in that building, and especially if weapons are involved, somebody may get hurt, somebody may get killed. So burglaries are very serious. I've read this pre-sentence investigation report a couple times. That's why it kind of sounded like Mr. Ripple knew exactly some of the things that my thoughts were when I read this, because he began that in his argument about Miss Bradshaw, and that there has to be two, and somehow the codes were given, and that you didn't do this alone. All of those things, those were thoughts that and questions that were going through my mind as well when I read this pre-sentence investigation report. And again, when I reread the criminal complaint and the facts that are alleged there. You do have an extensive criminal history going back to your juvenile years. You do have an extensive substance abuse issue and disorder that it sounds like you really do want to work through that. You want to do it not only for your children, but number one, you have to do it for yourself. Because if you're not doing it for yourself, you cannot, you won't put in the effort and you're not going to be able to do it for your children. You have to put yourself first, your sobriety first, and everything that it'll take to maintain that sobriety. When I look at needing to protect the public and that deterrence kind of factor, I do need to figure out a sentence that is going to deter you as well as the general public from engaging in crimes, similar crimes, especially burglaries, because they can be so dangerous and they are so serious. You've had a difficult life, definitely transitioning from multiple places, multiple locations. And I completely understand where you're saying that you went from a city that may have been around 1 million people down to Hinckley, where it's 900 people. That is definitely a shell shock. Definitely a shock when you're going from the ability to have resources at the tips of your fingers to coming to a place where even if Uber or Lyft existed, then you would not be able to have them. We don't have them here. We don't have a public bus service. We don't have taxis. We don't have anything like that, except for sometimes there are those sober ride taxis, sometimes during the weekends that you can call, but that's not often. And it's only a few individuals that want to do that to make extra money to bring people home. So definitely the environment, the resources are different. I don't know how you got hooked up or messed up with Miss Bradshaw, if you met her at a party or you met her at a friend's house. But from your attorney's argument, you do not have any connection here in Burnett County. Your connection would be the fact that we do have tribal organizations here. That's a connection, but you did not have an individual connection with our tribes and our Native American people. You had the connection simply because of Miss Bradshaw, and she was the one that brought you over, because it sounds like you didn't even come to the Burnett County casinos, or you didn't utilize anything here except for Ms. Bradshaw, correct?
Yes, ma'am.
All right. And I want to commend you with your speaking in your Native American language. It is a beautiful language, and I'm trying to learn some of that. Memengwe, butterfly. I know that, and I know a few things, but this is so culturally rich here with our tribes. And it is so good to see when a tribal member is getting back to your roots. You're getting back to where you belong in your life and teaching your children your culture and how to be a Native American. All right, because I don't want to see that lost. And I'm glad that you are in the Native American arts group and you're taking that seriously. And it really is amazing to hear you speak as fluent as you do in Ojibwe. If my court reporter could take it down, or if I could fully understand it, you know, I would allow you to speak in it throughout the entire hearing, but those are obstacles. But thank you for sharing your statement in Ojibwe. Mr. Staples, I do feel for you, hearing the story and knowing the story. And again, it's like Mr. Ripple did understand where my brain was thinking and had some of those things. And he answered some of them, as did Mr. Schmidt before we began. But for the fact of your contact and your meeting of Ms. Bradshaw, you would not have been in Burnett County. You would not have made contact with Burnett County. You would not have made the public unsafe with your conduct or your behavior. And you would not have even known Yellow Lake Lodge existed, and you would not have burglarized the business. Because it takes, in this matter, it took two to tango. And you would not have been able to tango without the codes to the security system, which she had because she was the cleaning lady. And so it did take her to provide those. And she wasn't charged, so I don't know the ins and the outs of that. I don't have anything but what is provided in the criminal complaint, as well as in this pre-sentence investigation report. I have the statement that she claimed that you had threatened her. However, I don't know why you would still be in Burnett County if you weren't continuing in some type of relationship when this matter occurred or whatnot. But I want to see you to continue to get these services that you need, because I do believe that you can rehabilitate. I do see your criminal record and it is extensive. What I am seeing, and I do see violence in your criminal record with the domestic violence charges and the domestic assault and the stalking and the violate no contact orders multiple times. And then there was the predatory offender knowingly commits an act or fails to fulfill registration requirement. And then battery. So I do see that in your history. For the most part, that is in the older history, except for the battery. And I believe the 2019 is what you were talking about, of the failing to register as that predatory offender. So there was a significant period of time from your last charge of possessing ammo and a firearm of 2015 to even the resisting an officer. That's 5 years, at least in this history of that I can see and I can gather. I want to see you take some classes, and I am going to order some that can help attempt to retrain your brain and your way of thinking, because I don't want to see you continue down this path, because you are still a relatively young adult. You were born in 81, so you have 11 children, and you have to show them how to be not only a great father, but a great citizen, a great community member, a great tribal member. You're the one who's showing them how to be in the future. And so if they continue to see you in orange or in brown in Minnesota or in all of those different colors, they will follow your footsteps. They will be where you are. They will be in that seat. And if you don't like going to prison, how would you as a father like to see your children going to prison? So you do have to make the changes, and you do have to do it now. Take charge, take control of your life, and do it, because no one else can, only you. With regards to this matter and having all of the facts and in the totality of the circumstances and arguments of the parties, what I am going to do is I am following I will follow the low end of the Department of Corrections recommendation with 3 years of initial confinement and 3 years of extended supervision. That will give you time to serve your Minnesota case. And I'm going to do it concurrent with your Minnesota case. And then if and when you're brought over to Wisconsin, you will then be able to do the challenge incarceration program. How old are you?
45, he's
So
too
you
old.
cannot do challenge incarceration program, but you can do the other earned release programs, the substance abuse program. And then you would be able to do that program and have the other remaining days be converted into extended supervision.
Okay.
Okay?
Okay,
Because I do see you doing things and improving yourself. So far, it's been in confined settings. So I think one more program will definitely help, and hopefully you can get your roots down and you can rebuild your life to what you should, or not should, what you could possibly be. Because I'm guessing the Joshua Staples that's in this black and white is not the Joshua Staples you want to be.
Correct.
So 3 years of of initial confinement, 3 years of extended supervision, again, concurrent with your Minnesota case, 143 days of jail credit, $1,000 of restitution that has already been prepaid. I'm going to order $500 in fines and fees and court costs. I'm waiving $18. It's $518. I'm going to waive the rest because you do have an additional $500 posted in this case. So then you are good to go on this end for those things. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I will go over your conditions shortly on extended supervision, but you may no longer use or possess a firearm for life. You're no longer able to vote in any elections until your civil rights are restored, except for tribal elections, and you can speak with your elders if there are and you want to participate.
okay,
I do need your DNA. The jail will make sure that they take it. It says that I don't have fingerprints. They'll make sure that they can get that. You would not be able to request it be expunged because this is a Class F felony. Conditions on supervision: absolute sobriety, no use or possession of any illegal drugs, substances, or paraphernalia. I am ordering that you engage in a program while in prison, or if not available when you're out of prison, so that brain changing program, the breaking barriers or thinking for a change. I like that you've done the parenting program, additional parenting programs. I'm not going to order, but I would like to see you participate in. Maybe there's one that the tribe does.
yeah,
Are you a Mille Lacs?
yes,
Okay, so Mille Lacs is great. Mille Lacs has so many programs and services available to their members. So utilize those to the best of your ability.
okay,
I'm going to order an AODA assessment and follow through. I am going to order an anger management. I'm torn here whether to order an anger management or a domestic violence because they're similar, but they're different. I'm going to order the domestic violence program and successful completion.
Your Honor,
Yes.
and that 3.5 high intensity program, they cover all that.
In what program?
That 3.5 high intensity program in Lino, they cover all that. That's all coincided with the program. Thank you for a change, anger management, that they provide that too during it.
And then what you'll need is you'll just need to get proof of completion of that program and get it to your probation officer, your extended supervision
Okay.
officer, okay?
Okay,
Because that would satisfy it. If they believe it satisfies it, I'm good to go,
okay,
okay?
You want to do your
Um,
probation, Hennepin County, right?
No contact with Yellow Lake Lodge
it'd be,
or the owners or their residents.
St. Paul, 'cause that's what transitions is.
I am gonna order also that you seek gainful employment, because I do know that you do receive a really good per capita. However, gainfully employed. You do have 11 kids, but you do need some time outside. And so outside of being a father, so maybe you can get a job, like you said, within the tribe. They have many job opportunities and they're very giving to their members. So hopefully you can find a job. It doesn't have to be full-time, just gainful. That just means that you're able to support yourself, support your kids, pay your bills, do those things.
Yes.
All right. I don't believe there's any other condition that's being requested. You would need to have any extended supervision transferred to Minnesota, but you can talk to your agent about that, and how to do that to get it transferred to Minnesota. So you can be overseen by an agent there. Mr. Schmidt, what am I missing?
Nothing from me.
Mr. Ripple?
I just wanted to make sure he can transfer his extended supervision.
He would be able to do that, yes, through the interstate compact, but generally it's within 7 to 10 days after sentencing, and you must pay $150 fee. If you want to follow up with Burnett County probation on that, Mr. Ripple, you can do so, but he would need to pay $150 fee to have it transferred. But since he is currently incarcerated, I don't know if that's applicable right now. It may not be applicable until he's transferred to Wisconsin and then gets a Wisconsin agent, and then they can do that to transfer it. But I'm not sure.
I'll follow up on that.
All right. Anything else, Mr. Ripple?
No.
Are you working on your emotional triggers too in that class?
Like impulsive thinking?
Yes, and how to respond instead of react?
Yes.
Okay. Because you really do need a focus on that.
Yeah, the big one was impulsive thinking. And they said they picked that one like right away after I was doing the interview or the little screening.
Okay, well, I'm glad to hear that. Good luck to you, Mr. Staples. I hope you all the best.
Thank you.
Thank you.
Yes.
Mr. Auberg.
Give me a call. Okay. All right, man.